3, 2, 1.
Good afternoon, everyone. This is Chad Radler. It's great to virtually be with all of you. Unfortunately, we're not in Ann Arbor, Michigan today, although I can look out my window, I see it is snowing here in Ohio, so it in some ways feels like we're up in Michigan anyway. Before we start, I want to thank the Federalist Society for so quickly being able to navigate this program online, and also say a very special thank you to the students at the University of Michigan Law School for all of their hard work really for the last year in putting what I know would have been a wonderful program in person together, and what is now migrated to be a virtual program. I know the students again worked really hard. I think everyone would have enjoyed their time had we made it to Ann Arbor. And so just thank you to the Federal Society and the students for all of their hard work in putting together this symposium. Well, our topic today is the changing norms and the political norms and their relationship with democracy. And in some ways, it's sort of an unusual time to be talking about political norms when all of our daily norms are upended in many respects. But it's also important, I think, to remember to keep, to certainly keep life as normal as possible, and to remember that these types of programs will help us during even these challenging times. And so we have 4 wonderful speakers we've assembled today to help us discuss political norms. Are they changing? Is that for the good? Is that for the worse? And so I'm really excited about our panel, and thanks for joining us. The topic is an interesting one. I know our speakers will dig into it a bit more. But as I was thinking about some political norms that maybe have been in the news over the last 5 or 10 years, there are quite a few of them. And I was thinking about maybe some norms just from individual branches of government that might be topics today or help set the conversation. But as you work through the different branches of government, in Article 1, for example, the legislature, one of the norms that's been in the news discussed recently and over recent years is the pace and the vote thresholds that the Senate employs in confirming officials for the other branches of government, both the executive branch and the judicial branches. In Article 2, we often talk about one norm is the relationship between the president or the White House and the Department of Justice, and what role, if any, the president and the White House should have in the department's investigatory and enforcement efforts, including prosecutorial matters. And then when we think about Article 3, a norm that's been discussed quite recently is perhaps the number of justices that sit on the Supreme Court. So these and many other make for really great discussion about what are our settled norms? Is it appropriate to change them? If so, yes, and if not, why not? I know that as the program goes on, you're able to ask questions. I think you can do that to comment either through the YouTube or Facebook live stream. If you do so, if you just list your name and your school and your question, we'll try to get to those near the end of the program. Let me take a couple of minutes introducing our speakers. We really have 4 terrific speakers from academia. I'm somewhat remiss to say that although this is technically a University of Michigan program, all 4 of our speakers are actually Yale graduates, 3 with JDs and 1 with a PhD. So I'll introduce our speakers in order, starting with Vikram Amar. Since 2005, Vikram has served as the Dean of the University of Illinois College of Law. He previously served as a law professor at the University of California Systems. His areas of expertise include constitutional law, federal courts, and civil procedure. Those are some topics that you'll hear all of our speakers cover. With respect to norms and sort of legal writing norms, I note that Dean Amar has sort of a foot in both camps. If you think of sort of traditional norms, he's been a co-author of the Treatise on Constitutional Law, and of course the classic Wright and Miller's Federal and Practice and Procedure Treatise. But if you think about more modern day norms, he is also a contributor to justia.com and abovethelaw.com. He's been a consultant to both the National Association of Attorneys General and the U.S. Department of Justice. And he's a graduate of the Yale Law School and a former clerk to Justice Harry Blackmun. Evan Kammaker. is the Dean Emeritus and Branch Rickey Collegiate Professor of Law at the University of Michigan Law School. I'll note if you don't know who Branch Rickey is, I hope you'll Google him after the program. Quite a historic individual. Professor Kammaker was the Dean at Michigan Law School from 2003 to 2013. And if we were all in Ann Arbor, you would be able to see a beautiful addition to the law school that was achieved during Professor Kammaker's time as Dean at the law school. It was a wonderful addition, and I know all the alumni are quite appreciative of the Dean's work during his tenure. He teaches in the areas of constitutional law, federal courts, and civil procedure. He is a graduate of Yale Law School and a former clerk for Justice William Brennan. And he's previously served in the United States Department of Justice, both as a special assistant U.S. attorney, all the way up to service in the Office of Legal Counsel as a deputy assistant attorney general. Third, David Bernstein is a professor and the director of the Liberty and Law Center at the Antonin Scalia School of Law, where he's been teaching since 1995. He's been a visiting professor at many other top law schools, including the University of Michigan. He's a prolific author. He's authored over 60 frequently cited scholarly articles, and he teaches constitutional law and also in some very practical areas, products liability and evidence. He's a graduate of Yale Law School, where he was a John M. Olin Fellow in Law, Economics, and Public Policy. And I think it's important to note, selfishly, that he's also a former law clerk on the Sixth Circuit to Judge David Nelson. And he's a contributor to the Volokh Conspiracy. Keith Whittington is the William Nelson Cromwell Professor of Politics in the Department of Politics at Princeton University. He's also a prolific author on topics like American constitutional law and the judiciary. Many of his writings have won book prizes, including Repugnant Laws, Judicial Review of Acts of Congress from the Founding to the Present, which won the Thomas Cooley Book Prize, and Political Foundations of Judicial Supremacy, the Presidency, the Supreme Court, and Constitutional Leadership in U.S. History, which won 2 book prizes. And although Professor Whittington is not technically a law professor, he has taught at various law schools, including the Harvard Law School. He has a PhD from Yale, and he is also a contributor to the Volokh Conspiracy. So with that, again, I think we're in store for a wonderful conversation, and we'll start with Dean Amar.
Thank you so much, Judge. And thank you to the Federalist Society for putting together today's wonderful program. And I want to echo the judge's quite a poignant reminder that even as we live in kind of a surreal moment, that it's very helpful to remember that this too shall pass, and the themes that we're going to be talking about today are ones of abiding importance. So I look forward to our discussion. The prompt, if you will, for this panel, and I tend to think this is midterm season, so I think of how students would answer a particular question. The question posed here is, do changing norms undermine support for our system of government? I think there's really 2 parts to that question. One is whether the norms have changed, and I think the judge is right that they certainly have. And then second, have the changes in norms really affected a popular belief or support or faith in our constitutional government? And on that part, I'm not as sure, but I guess what I'd say is, to the extent that they have undermined faith in our government, it's because the people may not appreciate the difference between norms on the one hand and constitutional or legal rules on the other hand. That the changing of norms is built into the system, and there ultimately are a variety of checks and balances that the people have to make sure that in the long run, norms are consistent with popular values. So with that framing, let me turn to discuss a little bit more depth of why I agree with the judge that there really has been changes in the norms. I'll just offer several examples, some of which were hinted at by Judge Riedler. Congress's norms certainly have changed in recent years, talking not just about filibuster practice and blue slip practice, but even the process that leads to the enactment of quite significant legislation. Look, for example, at the rapidity with which the tax cut bill became law after President Trump was elected. That was an astonishing process compared to the much more cumbersome, much more procedurally laden process that attends most major legislation. Think about how long Obamacare took to get through and how many hearings and battles there were over that. The repeal of the tax penalty provision in Obamacare, that linchpin that has occasioned the Fifth Circuit's invalidation of the whole law as being unseverable, a question before the Supreme Court right now. That too was done with astonishing speed and efficiency, depending on how one looks at it. Staying with Congress and turning to the appointment process that the judge adverted to, it's not just filibuster practice that has changed. Of course, it wasn't so long ago that we were talking about how unusual it was for the Senate to have declined to give Judge Garland a hearing or a vote when President Obama nominated him to replace the vacancy created by Justice Scalia's death. Or more recently, when you look at the confirmation processes of both Justices Gorsuch and Kavanaugh, the reduced role played by the American Bar Association and its vetting process, and correspondingly, perhaps, the increased role played by the Federalist Society in these nominations. And I'm not opining on whether that's a good or a bad change in the norm. I'm just commenting on the fact that that is a deviation from a pretty long-standing practice of several decades. And then, of course, the norms with respect to the executive branch and in particular the White House, the Oval Office, have changed tremendously. That was the whole thrust of President Trump's campaign in 2016, that he was going to be a norm changer, that he wasn't going to act like other presidents, that he was going to redefine what it means to be presidential. And the judge pointed out in particular the relationship between the Oval Office, the White House, and the Department of Justice has evolved, where the president has weighed in publicly and taken actions, not just issued statements, with regard to, for example, the Russian election meddling investigation, and the FBI director James Comey and his job security, commenting on sentencing proposals concerning Roger Stone and the like. Indeed, the norms extend beyond the investigative and prosecutorial realm to comments on the judiciary. A lot of what we have seen in recent years has been a much different kind of discussion about judges emanating from the White House. And that even carried it over to the Senate. I mean, Senator Schumer's attack on Justices Gorsuch and Kavanaugh, which caused him to apologize shortly thereafter, was really, really new and different. So these norms are definitely ramifying throughout all three branches. But I guess the extent that people are up in arms about these changes in norms, in part it's because they don't understand that none of these changes in norms, whether normatively attractive or repulsive, really bump up against constitutional limitations. These are practical, political, quasi-legal norms. They are not legal rules or constitutional barriers. So, for example, let's just take as an illustration the president's larger voice and larger role in Department of Justice investigations and prosecutions. A lot of presidents since World War II have perhaps quite smartly distanced themselves from day-to-day criminal procedural investigations and prosecutions in the DOJ, to the point where some journalists will talk about the president and DOJ and the FBI as totally separate entities. The reality is, FBI is part of DOJ, and DOJ is part of the executive branch headed by the president. The president is not just the commander-in-chief. Under the Constitution in Article 2, he's the investigator-in-chief, he's the prosecutor-in-chief, he's the declassifier-in-chief, he's the partner-in-chief. And whether it's good as a policy matter to distance oneself from day-to-day operations. That doesn't mean as a constitutional matter, it's problematic for the president to stick his nose or his finger in the process or the pie. And let me give you a kind of an example that I use with my students to drive this home. If Hillary Clinton were still being investigated at the time that President Trump took office for the email carelessness that she was clearly guilty of, and there was still a DOJ investigation going on as to whether she should be indicted and prosecuted. And President Trump came into office and said, much like Gerald Ford from the state of Michigan did after Watergate, the country needs to heal. And so whether she's guilty or not, whether a private person would have been prosecuted for what she did or not, I'm going to direct the DOJ to stop this investigation, and there shall be no indictment or prosecution, because I think that's in the public interest. No one in the world would say, well, that's problematic because the president should maintain distance from DOJ. The president shouldn't be dictating who gets prosecuted, who gets investigated. And I think the reason why we would have no problem with that is because motive, intent, purpose would not be in question. And I think if you take a step back and you look at the edginess that people have over a lot of these changes in norms, it's really not an aversion to the idea that these norms can change, but it's an aversion to the idea of why these norms are changing in their particular instances. And indeed, I think implications of illicit motive or intent lurk behind so many of the major monumental constitutional questions we've confronted over the last few years. So let's take the travel ban, the census case, the Ukraine investigation, just three big ones. Of course, presidents have the power to regulate entry of people from different countries in different ways. We see it today, yesterday, arising out of the coronavirus. No one's saying that it's wrong to discriminate against people coming from some countries rather than others. The question is, why those countries? Was that an anti-Muslim ban? Was there some ulterior motive? Census case. Nobody denies the federal government has the power to ask citizenship questions at the census. Indeed, the Section 2 of the 14th Amendment might require the federal government to know how many citizens there are in order to decide a certain question. Again, the issue is not the whether or the permissibility, it's the why. Why is the federal government doing it in this instance? And so too with the Ukraine matter. I get so frustrated when I hear the term quid pro quo, as if it were an inherently bad thing. Every contract is a quid pro quo. Quid pro quos are good things in the main. The question is, why was there an insistence that if there was one, that Ukraine investigate publicly Senator Biden's son? It's all about motive. And one thing that I think we've seen in the past few years is that the federal courts are not very comfortable in invalidating measures by the executive branch on the ground that they are otherwise permissible, but in this case motivated by an illicit purpose. When the travel ban case was in front of the Supreme Court, a number of lower courts had invalidated various iterations of the travel ban. And my older brother, who teaches at Yale Law School, and I were talking, and I said, Akhil, I don't really get this. I don't understand. This seems like it'll pretty clearly be upheld by the Supreme Court. And not just because I'm counting 5 conservative votes. I asked Akhil, I said, do you know how many times the Supreme Court has invalidated an action by the president on the ground that it's permissible but illicitly motivated? And the answer was 0. And I asked him, I said, you think they're going to do that for the first time in the context of immigration in this setting, when we're regulating entry into the United States of people who are not United States citizens and don't have particular strong ties to the United States? So it's pretty clear that unlike the federal court's attitude towards state and local government, when it comes to coordinate branches, especially the executive branch, the federal courts aren't going to be policing the state of mind or the intent of the president, even as he disrupts norms generally. Well, if not the courts, then who else can keep our norms in line or preserve them? Well, there's of course Congress, and that's what we saw in the impeachment investigation and trial. But there too, there are now structural reasons why congressional investigation and impeachment are not likely to be very norm reinforcing. We live in a time where party trumps institution. People tend to think of themselves not as a senator who happens to be a Democrat, but rather a Democrat who happens to be in the Senate. And what that means is a lot of the checks and balances in the Constitution, whether it's passing legislation, proposing amendments, convicting people for high crimes and misdemeanors, all these things require supermajorities, and supermajorities don't work in times of hyperpartisanship. The reason that Gerald Ford became president was because Republicans joined with Democrats to tell President Nixon that the jig was up, but that was a very different era than the one we live in. And so if you take a step back and you ask in a real big picture, what did the framers rely on? What techniques or strategies or devices did they rely on to really keep norms on an even keel? I think there were kind of three different strategies they used. One was the idea that actors in the federal government have only limited enumerated powers. So that's the idea embodied in the 10th Amendment. But because the world has changed, because the economy has changed, because the nature of international relations has changed, because warfare has changed, because presidents are much more democratically accountable now than they ever used to because of reforms, practical reforms in the way the Electoral College works. At the founding, of course, state legislatures picked the electors to the Electoral College. Now the people of all states do it, and it would be nearly impossible for a state legislature to try to reclaim that power. For all these reasons, both Congress and the president have a lot more authority than they used to, and the doctrine of limited enumerated powers isn't nearly as constraining. Second, we do have enumerated rights that are enforceable by an independent federal judiciary. And that's certainly a strategy that has been relied on a lot since the middle of the 20th century, since Brown and Roe and all those cases. Courts are the saviors by coming to the rescue and reining in the other branches of government. But as I mentioned earlier, when the questions are ones of state of mind and bad hearts, the federal courts are not going to be in a position to tell their coordinate branches, you guys are lying, you guys are evil, we're going to strike down your actions. Which leads us to the third device they used, which was to disperse power widely, checks and balances, federalism and separation of powers. But again, those things work much better in moments where there's not hyperpartisanship. When you need supermajorities to operate the levers of those checks and balances, you can't really rely very much on that. That's why the impeachment trial was doomed to fail from the start, and nobody ever thought that this president, or President Clinton for that matter, was going to be convicted at the end of the impeachment trial. So that brings us, I think, to the biggest kind of check and balance, and that's the electoral check. And to the extent that people really have lost confidence in government because of the changes in norms, then it's up to them to re-enshrine the norms that they want to preserve when they act at the polls. And that's what I think you're going to see this 2020 election about, is really, if it ends up being Joe Biden against Donald Trump, it's really going to be about these norms and these values and these practices and these traditions, and which ones the American people want to choose to adopt, or in some cases re-enshrine. So with that, let me stop and turn it over back to you, the judge.
Great. I think Professor Kammaker is up next.
Terrific. Thank you very much. Sitting here in Ann Arbor, I wish I could say welcome to our law school in town. Under the circumstances, the best I can do, here's a snow globe with the University of Michigan, law school's beautiful building right in front. Judge, I'm not going to shake it. It may be snowing where you are in enemy territory in Columbus, Ohio, but it's a beautiful day here in Ann Arbor. Hopefully all of you will have another opportunity to come join us at some point in time in the future. Let me also say a big thank you to the students. Obviously, you put together an incredible, actually, I'll say 2 symposia. There was going to be a fabulous one here over the weekend. Very sorry you all couldn't be here for that. Trust me, being at a banquet at the big house, that should be on everybody's bucket list. And thank you again for working so quickly to pull together this fabulous online version of it, which we're all excited to be here about. And thank you again for inviting me to join. I'd like to follow Vic by focusing on one particular norm concerning the president that I think is being broken more and more in recent times, and that I do think over time will lead to reduced support or feeling of respect for the office. The norm is that there is an important distinction between, first, the office of the presidency, and secondly, the person who happens to be the president. Back at the framing, we had a romantic notion that the president was accountable to and would serve the interests of all of we, the people. And soon after that, political parties rose. Presidents started representing realistically smaller and smaller groups of we. In recent years, I think one can fairly say that most presidents at most times have largely been representing large pluralities rather than even a majority we. Certainly that's true of our current President Trump, though his plurality we happens to be a particularly vocal and loyal group. My concern today is that recent presidents, and in particular this one, have increasingly veered away from we the people in a way that even their core supporters should not cheer. And that's by prioritizing themselves, their personal interests, over any legitimate governmental objectives at all. It's a slightly different point than the one Vic emphasized about motives. I'm not questioning whether or not somebody's motives are unconstitutional in some way. The question is whether or not they are putting the me before the we and we the people. And I want to illustrate this in two different contexts. One that'll be more familiar and visible to you, doing wrongs and defending wrongs. With respect to doing wrong, I think even recently we can see this particular president putting personal goals seemingly ahead of the public interest. Examples come readily to mind, whether that's encouraging government staff to stay at personally owned hotels, downplaying national security concerns out of a fear that acknowledging them would somehow undermine his perceived legitimacy. And obviously, most recently, the tendency to downplay obscure facts about our current health crisis because it may undermine the narrative of everything's fine, and in particular, I'm winning. Now, to be clear, all recent presidents have healthy egos and have occasionally, if not more regularly, engaged in self-puffery. But I generally worry that more recently, and certainly the current president, is beginning to bend the self-puffery and self-focus beyond the breaking point. Again, putting me again ahead of any plausible subset of we the people. At important times like now, critical situations, presidents care more about promoting themselves, the person who is the president, rather than exercising the powers of the presidency. And again, I worry if this trend continues through a future Trump presidency or future presidents to come, I worry ever more about the increasing growth in both power and stature of the presidency within our constitutional system. But let me shift to the flip side, a less visible place where this norm is breaking down. That has to do with defending wrongs. Starting with President Nixon, both Republican and Democratic presidents have aggressively claimed immunity from criminal prosecution, civil litigation, and investigative subpoenas. President Trump is now taking these arguments to even new levels in a series of cases, claiming that interference with the personal self automatically translates into interference with his official role. In other words, he claims inquiries into wrongdoing by Trump, the private citizen, should be presumed to unconstitutionally burden Trump, the president. And I'm going to focus on two cases before the Supreme Court this month. Although, again, I want to be clear, he's really just adding the logical progression of these legal arguments that have begun from presidents over the last 40 or 50 years. One of the cases before the court is Trump against Mazars. It involves a set of legislative subpoenas issued by several House committees seeking Trump's personal tax and financial records. The requested records clearly involve Trump as a private citizen. They are from a time period predating his election. And the subpoenas seek those records from accounting firms. So Trump personally doesn't actually have to do anything to comply with the subpoenas. But he argues, nevertheless, that the subpoenas would, quote, impose an unacceptable burden because they would distract the president from his official duties. The Solicitor General puts it this way: quote, a subpoena for personal records can have the effect of diverting the president's time, energy, and attention from his public duties. This is true because the presidency is tied so tightly to the persona of its occupant, making the line between official and personal both elusive and difficult to discern. The second case is Trump against Vance. There, a New York district attorney began to investigate whether President Trump, Trump Organization, or other people involved with the organization committed various financial crimes, including the so-called hush money payments. The grand jury served subpoenas on Trump's accounting firm, again, seeking his personal tax and financial records. This time, President Trump affirmatively went to federal court seeking to enjoin his accounting firm from complying with the subpoena. And the core argument is that in a state court, a sitting president enjoys temporary immunity from any criminal process at all, even early discovery, as part of an initial investigation. Now, as background, you probably are all aware that the Department of Justice Office of Legal Counsel opined in the year 2000 that a sitting president is immune from federal prosecution in terms of indictment and then subsequent prosecution in a federal court. As the judge noted in his overly generous introduction, I actually worked at OLC. I happened to be a deputy there at the time, and I worked on that opinion for the office. I acknowledge reasonable people can disagree with OLC's position, and frankly, some days I'm one of those hopefully reasonable people. But whatever one thinks of the position, President Trump in these filings is going way beyond this claim. The OLC opinion makes very clear that prosecutors and grand juries can still go on with pre-indictment investigations. But the president now says he's completely immune, at least in a state court, from all process, including pre-indictment investigation, and not just for official conduct, but even for purely private conduct. And this is, again, because any enforcement action that operates against him in his personal capacity also counts as operating against him in his official capacity. He also here complains about personal diversion and personal distraction. Now, again, he can't really claim that the subpoena directly interferes with his activities at all, because the subpoena doesn't target him or personally require him to lift a finger. But his time will be diverted from governing, he says, because naturally he'll begin in his private capacity to, quote, consult with his attorneys, consider the need to assert privileges, and otherwise participate in his defense. He'll become distracted, he asserts, because again, in his personal capacity, he'll become mentally preoccupied with a criminal investigation. So he'll be less focused and hence do a worse job when acting as president. Now, as a matter of doctrinal reasoning, I find these arguments quite strained. The claim that triggering citizen Trump to spend time worrying about future proceedings significantly interferes with his current official performance seems a real stretch. Among other things, it falsely assumes that the president has zero downtime, such that any hour spent stressing about this personal matter is an hour taken away from representing we the people. Now, for someone who spends as much time on the golf course as he does, or a previous president spent on the basketball court, I think we can question this premise. But more importantly, look how far the logic runs. Many actions taken by governmental actors might similarly distract the president, and perhaps even require him to spend time away from presidential duties. In this case, maybe the IRS would aggressively audit President Trump's personal tax returns. Maybe a county in Florida would exercise eminent domain over Mar-a-Lago. Maybe a prosecutor would charge Ivanka's company with false advertising. There's any number of possibilities we could think of where something would affect the president through state action in his personal life that would require him to spend some time worrying or thinking about it. So once unmoored for any direct impairment of the president's ability to set and implement his own official agenda, this distraction/diversion argument really has no limiting principle. So it's one thing to protest actual criminal prosecution, but it seems another thing entirely to claim immunity from criminal discovery, especially, again, under circumstances in which the president doesn't really need to lift a finger. So back to the big picture. In both doing wrong and defending against wrongs, there's a growing propensity for the president to equate his person with the office. And in my view, this moves us away from a presidency originally envisioned, in which the person temporarily donned a role on behalf of we the people. And it moves us dangerously closer towards a regime that at least has not, if not the powers, but the attitudes and trappings that smack more of a monarchy than a democracy. Thank you very much.
Great, thank you. So we've heard two excellent talks about maybe some recent changing norms, and perhaps we'll get a slightly different perspective from my next two speakers. Up first is Professor Bernstein.
Thank you, Judge. Thanks also to the students for all the work on this. I'm disappointed for you that the conference couldn't go off in Ann Arbor. I'm disappointed for myself. I visited Michigan for a year, and I have a lot of fond memories of my time in Ann Arbor. A beautiful day that Evan says that they're having is not in the middle of the winter is not something I remember very much of, so I'd like to have experienced that. In any event, I want to talk a little bit about executive power writ large. Vic already made one of the points I was going to start with, which is that we have a real structural problem in our constitutional system with separation of powers. The authors of the Constitution expected that Congress would have the institutional motivation to protect its prerogatives and limit executive power, ambition counteracting ambition, and so forth. But it turns out the president also serves as the leader of one of the two political parties, which were not necessarily anticipated by the framers. And people think of themselves, as Vic said, not as a senator who happens to be a Democrat, but a Democrat or Republican who happens to be a senator. And these members of Congress don't want to limit the authority of their president when someone from their party is in office. So Congress lacks in general the incentives and willingness to restrain the president. In the past, when things were less ideologically divided, when there were still many liberal Republicans and conservative Democrats, when you had people like Senator Robert Byrd of West Virginia, who were real institutionalists and believed in preserving the power, you could occasionally have situations when Republicans and conservatives would Democrats, I should say, would get together to restrain the president. Already the Nixon impeachment was mentioned. You could also mention the 1937 court packing plan of Roosevelt, which, the Republicans were a small minority in 1937, but they got enough Democrats who also were concerned with what they saw as a power grab to tell the president it wasn't going to go through. So we don't really have that sort of thing anymore, and the result has been ever-growing executive power that's only really rarely constrained by Congress. And to make matters worse, Congress itself invites the expansion of executive authority by granting broad delegations of discretionary decision-making power to the president. And when you have some of these laws that just say, oh, if there's an emergency, you can do whatever you want, all we can really rely on is the self-restraint and norms of behavior of the presidents. So without that in mind, I wrote a book published in 2015 called Lawless, where I documented many of what I saw as the Obama administration's abuses or unwarranted expansions of executive power. And I knew that people were very enthusiastic about Obama if they were Democrats, and I didn't really expect it to have much of an impact on their thought. But I understood there was an election coming up and primaries in the Republican Party, and I was kind of hoping that at least on the margin it might promote some discussion and debate about how maybe this is a good time for Republicans to advocate the retrenchment of executive authority to some extent and restore sort of a more modest balance between the branches, and to have a president who is modest and constitutionally savvy enough to try to restore that balance. And we know how that worked out. Obviously, my book didn't have much of an impact. And instead of a modest, constrained president, we got Donald Trump. And Trump, whatever his other virtues may or may not be, often talks like someone who would like to ignore or abolish constitutional restraints on the presidency, not just when he said that Article 2 lets him do whatever he wants, but also pesky things like the First Amendment he sometimes seems to find to be nuisances. But the good news, or at least the not so bad news, is that Trump, despite a lot of rhetorical excesses, hasn't really done much of anything novel to expand the legal authority of the presidency. That's not to defend Trump's assertion of executive power, which often go beyond what I see as the proper scope of the constitutional limits of such power, but simply to note that all of the abuses of executive power I can identify, almost all of them, you could find precedent in the Obama administration and beforehand. In fact, one could argue that one reason why the president Trump can't really expand executive authority that much is that it's been expanded so much already by past presidents that there isn't that much left. The bad news, or the additional bad news maybe, is that in the absence of Congress being able to check the president's power or willing to check the president's power, our system relies on informal norms to keep some semblance of balance between the branches and some semblance of limits on executive authority. Unfortunately, in these partisan days with Congress deadlocked and with one house of Congress often in the hands of the opposite party of the president, there has been a gradual decline in adherence to such norms. It was mentioned previously that nowadays the president is much more responsive to public opinion. I think presidents come in thinking, I was elected to do this or that, and Congress's job is to go along with me, not to serve as an independent brake on what I want to do. The decline in norms that we've seen in recent years, you could arguably at least start in earnest during the George W. Bush administration, when the president issued a series of executive orders to implement priorities that in the past would have been debated and decided in Congress, or sometimes Congress would pass legislation and he would issue a signing statement saying he's not going to go along with parts of it that he thinks impinge on his power. There was nothing inherently illegal about most of what the president was doing or saying, and arguably he was within his authority in many of these, or even all of these matters, but they did represent a move toward executive unilateralism in violation of long-standing norms about when the president should act unilaterally, not whether he could act or whether he should act unilaterally. Bush's defenders pointed to a gridlock Congress and national emergency after 9/11, the war on terror, to justify his actions. So, it wasn't that there was no justification. It was not solely an aggrandizement of power, but still it was. Similarly, Bush was promiscuous in his use of so-called czars, non-confirmed government officials, to get around the confirmation process and avoid confirmation battles that could be politically damaging. And this elicited much criticism from Democrats, but not nearly enough from Republicans. Now, President Obama campaigned in 2008 as someone who wanted to rein in executive power, especially with regard to war powers. But his supporters were basking in the glory of the fact that he was really the first president in decades to have run and won as an unabashed liberal or progressive, and they were hoping for significant change. Our system, with its checks and balances, is really not designed for sudden change unless there's really overwhelming majorities like in 1964 or 1932. So there was a problem here. Do you want to have constrained executive authority, or do you want to engage in this progressive change that your supporters want, that you want to do, and that Congress probably won't go along with, at least not in the supermajority way that you need to get things through the Senate, for example. So pretty quickly, Obama, even when he had control of both houses of Congress, revealed impatience with checks and balances. He appointed even more czars than Bush did, often individuals who have faced very difficult confirmation hearings. Faced with economic crisis, he used the TARP bill to bail out the automobile industry and actually even appoint in practice the head of General Motors, despite really dubious statutory authority for doing so. During the 2010 elections, he and others high up in his administration and the party attacked the Koch brothers, what I think was sort of an unprecedented attack on specific private citizens. That's hard to say was anything except an attempt to intimidate Republican donors. He wanted Obamacare to be bipartisan, which all major social legislation had been beforehand. But people put the blame in various places, but it does seem from the research I've done that he was not really willing to engage in the sort of compromises that the few senators who were Republican and possibly would have voted with him were requesting. But Republicans, he invited Republicans to propose things to put into the stimulus bill. In early 2019, the Republicans in the House presented him with a list of 20 items that they thought he might agree to. He put none of them in the bill, and the stimulus bill wound up passing along party lines, which is also sort of unusual in economic crisis. When BP had a major oil spill, he met with BP leaders, criticize them publicly and sort of jawbone them into a settlement, even though it's not really clear what the president has to do with private legal claims based on the oil spill and so forth. Some of these actions to keep that distinction between law and the Constitution norm, some of them were clearly lawful. I mean, you could attack the Koch brothers all you want lawfully, just for example. While in other cases, the administration was at least careful in general to provide at least a colorable rationale for its actions. But all of them, all these examples were violations of long-standing norms. Once Republicans got a foothold in Congress, things got even worse norms-wise. Obama, for example, publicly had declared over and over that he lacked the authority to do anything about the legal status of the Dreamers, that Congress had to act. But then when political pressures became too much and the Republicans clearly weren't going to pass anything, he just passed an executive, issued an executive order changing that. Having failed to get climate legislation through Congress, he had the EPA make the same policy changes through regulatory changes. When snafus arose with Obamacare, he issued executive orders and public pronouncements modifying important parts of the legislation on the fly to the degree that it actually seems kind of dangerous to let the president do this sort of thing unilaterally. The Department of Education issued major guidance to universities about sexual assault cases without even trying to go to Congress to get legislation passed and without going through the Administrative Procedure Act. The Iran nuclear deal that President Obama negotiated, I checked this with John Manning, who's more of an expert on this than I am, violated all sorts of norms of congressional approval, transparency, transfer of funds to foreign powers, and more. Again, not necessarily illegal, but definitely a violation of norms. Well, I blogged about this and eventually wrote the book, and I encountered a lot of supporters of President Obama who defended these actions, and they said, look, depending on what the issue was, first there was an economic emergency, right? We had to get things done so the economy wouldn't collapse. Most members of Congress supported immigration reform, but the Republican leadership wouldn't allow a floor vote, so we were really acting according to majority will. Republicans were intent on destroying Obamacare, so of course we couldn't negotiate based on changes. The Iran deal was crucial to international security. We couldn't play politics with that. We just had to get it done. Without doubting the sincerity of those defenses, they all ultimately rely on two notions. The first is that Obama is trustworthy, so if he feels it necessary to break norms, it must be for good reason. The second was that these norms violations wouldn't serve as precedents for all future presidents, whether they were trustworthy or not. The problem, of course, is that Republican partisans predictably did not share either of these perspectives. They didn't think Obama was trustworthy, nor did they accept the notion that the precedents established by Obama shouldn't be applied or indeed expanded to Trump. And when Trump started running for president, I asked some of my Democratic friends, well, are you really happy? Would you be okay with Trump exercising this sort of authority in various matters unilaterally that Obama has? And they just sort of chuckled and say, well, Trump will never become president. We don't have to worry about that. Trump, of course, has gone way beyond other precedents in violating norms of decorum. And Vic and Evan talked about some other norms, like about president getting involved in criminal prosecutions and maybe doing some self-dealing that Trump has been especially promiscuous in violating. But there are other issues in which he's said to be violating norms in the exercise of executive power that are precedented. For example, making a lot of policy they can't get through Congress via executive order and the regulatory process. Pressuring private companies to change their economic policies to suit the economic policies of the administration. Emergency declarations. I looked up, I thought it was outrageous that Trump had declared national emergency for immigration. Then I looked up what other presidents had done, and they had declared national emergencies for all sorts of really picayune nonsense. Making immigration policy by executive fiat, engaging in important foreign policy initiatives, including military action without consulting Congress, much less giving Congress a chance to weigh in, aggressively interpreting statutes and serve policy goals, using acting officials rather than czars to evade the confirmation process, and so on. Democrats, not surprisingly, strongly criticize these actions, and Republicans, in turn, are quick to point out precedents from the Obama administration and earlier precedents to say, well, why weren't you concerned when Obama was doing similar things? Democrats, of course, in turn, try to make fine, fact-specific distinctions, but ultimately the main basis of their argument is, but that's different. You surely can't be saying you trust someone like Trump with this sort of authority. Now, whatever the objective merits of the Trump is different argument, it's inevitably going to be entirely unpersuasive the people who actually like and support Trump and disliked and did not support Obama or other presidents who engaged in similar actions. In short, norms of presidential behavior, along with other norms of our constitutional system, no matter how ancient, are fragile things. In these partisan, bitter times, with Congress generally deadlocked, it's inevitably tempting for each partisan side to violate norms because the other side is being, in their view, recalcitrant, obstructionist, or indeed violating behavioral norms of their own. Like was Congress, maybe Congress was violating norms and not being sufficiently cooperative with Obama, as people argued. But we should all be warned. Each time a norm is undermined by one side, when the other side gains power, it will very likely use that norm violation as precedent and indeed push the norm violation even further. Eventually, and perhaps quite quickly, whatever constraint the norm put the exercise of executive power or other government power will dissipate entirely. Thank you.
Okay, thank you. And now Professor Whittington.
So thank you very much. So I appreciate everybody willing to do this. I'm sorry that the symposium didn't come together in a physical location like we would have hoped, but I'm glad we're at least able to do this, and I'm glad to be able to participate in it, and to participate in this particular panel, which I think is an particularly important one. We have given more attention to the issue of norms recently, maybe specifically during this administration, than we have more generally. But I think it's high time that we, in fact, pay attention to norms. They're an essential part of how our constitutional system works in general, but they tend to be underanalyzed. We don't pay as much attention to them as we should. We don't have good tools for thinking about them. And I don't even think we have very good tools for identifying them. And so I think this will be a useful moment for us to try to grapple with the fact that the Constitution vests an awful lot of discretion in government officials of all sorts. And norms are part of the process, part of the sub-constitutional sets of practices and rules by which we make the constitutional system work better, despite the fact that it entrusts vast discretion to government officials more generally. I think even as we talked about on this panel, the phrase norms has encompassed an awful lot of different kinds of activities that sort of qualify as sort of part of these sub-constitutional sets of practices. So we might think of some norms as really being purely a matter in formal practice, but we might imagine others that get institutionalized to some degree. So we might imagine some rules about congressional practice, like the Senate filibuster or how the House committee system works, as being similar to a norm, even though they are in fact entrenched in a set of rules. They are part of the sub-constitutional set of practices that regulate how government officials conduct business within the terms of the Constitution more generally. And we think they serve very important functions and do important work within the constitutional system more generally. Some of them may be built into statutes. And so there's a host of sort of framework statutes that are particularly important to how the government operates more generally, and we think they might serve those similar functions as well. One of the tricks, though, I think when we particularly think about informal norms, the kind that are not built into some kind of regularized sets of rules or practices, is trying to even recognize what they are, so that we know when a norm violation has occurred and whether or not we ought to be particularly concerned about it. At the very least, we think that norms are part of a regularized set of behavior. And so for an outside observer watching a political system, we may be able to infer that there's a norm based on how people are behaving more generally. But that by itself probably isn't sufficient. So for example, it has become the regular practice of recent presidents to nominate people to the US Supreme Court only who have some prior judicial experience before that nomination is made, and largely people who have gone to Harvard and Yale Law School in particular, and in many cases, people who have gone to Princeton University as undergraduates. It's hard to imagine we would think of that as being a norm if a president decided not to follow that regularized practice, but instead chose as a judicial nominee to the Supreme Court someone who had not gone to Harvard Law School, but instead went someplace else. If they had not had prior judicial experience, we wouldn't necessarily think it's a norm violation, but it's certainly a break from routine practice. So that raises questions about when is it a norm and such. We all worry when presidents deviate from it or other government officials deviate from it. And when should we not worry so much? Because it's simply changing what routine behavior looks like. Sometimes this is a function of breaking regularized practices, so that may signal something about a norm being changed. Other times, though, it's less true. So, for example, early in the Trump administration, President Trump was criticized for the fact that he maintained his personal Twitter account, raising questions of, is there some kind of norm that presidents shouldn't have personal social media accounts that they continue to use over time? Trump famously, and in all caps, blasted on Twitter that he is modern day presidential. He behaves differently than other presidents have to some degree. And among the modern day features of his presidency is that he will use a Twitter account in a personal capacity. We don't have a long practice that tells us presidents shouldn't do that kind of thing. And so we're constructing norms on the fly as to whether it's okay to have a personal Twitter account, if it is okay for a president to have a personal Twitter account, and how should he use that Twitter account, what kind of behavior on that Twitter account might be acceptable, and the like. And then those things are going to change over time, and it's a challenge to try to determine when do we know that some kind of norm has been established, and when do we not. Part of what also complicates thinking about when norms have occurred is we recognize that there are likely to be exceptions to norms over time. So even if we think something has a norm-like quality, we recognize, just like rules, that norms can be violated in various ways. And then the question is, well, when do the violations accumulate such that we in fact think the norm no longer holds? And it's in fact been broken such that now we can move forward without it, as opposed to simply thinking these are violations of the norms, but the norm itself holds going forward. So think about the example of faithless electors, for example. So the US Constitution sets up a system, obviously, of an electoral college that has actual human beings serving as presidential electors who cast ballots a month after the voters themselves cast ballots for the presidency. All through American history, presidential electors have been pledged electors. That is, when they are selected to hold this office, they have pledged themselves to vote for a particular presidential candidate. But some presidential electors violate that pledge and vote for someone other than the person that they were pledged to vote for in the first place. We call these faithless electors. So you might think that there's a norm for presidential electors, one, to make pledges, and also to adhere to their pledges over time, and actually cast their ballots in favor of the person that they were elected to that office to actually cast their ballots for. But the fact that we have this long practice of, in fact, having faithless electors, we can observe faithless electors all through American history, sometimes more than other times. The 2016 presidential election featured quite a few, as well as a lobbying campaign to create even more. Is it still a norm that electors should not be faithless, despite the fact we have these examples of electors being faithless over time? And some of that question, I think, as to when we recognize something as being a norm and when we don't, when it's just routine behavior as opposed to some kind of normatively binding behavior, does turn in part on partially what the internal motivations and understandings are of those engaged in the practice. Do the people who are engaged in this practice recognize it as a kind of norm, such that this ought to guide their behavior and constrain their behavior in various kinds of ways? And likewise, is it blameworthy if they violate that kind of practice over time? So, for example, I think it's the case that we would say that most presidential electors believe as part of their internal practice they ought to adhere to their pledges. Moreover, we think it's blameworthy if they do not adhere to their pledges and violate their pledges in various ways. But ultimately, those are empirical questions about whether or not that's true, and it's a challenge to maintain and enforce that sense of norms in these instances in which people might violate them. So it was suggested earlier in our discussion, for example, that major pieces of social legislation often get bipartisan support, and that's been true through much of American history. Certainly it was true through much of the 20th century, that major pieces of legislation get bipartisan support. Hard, I think, to think, though, that that's a norm. Particularly, it's not obvious that any of the players think internally that they have to have bipartisan support in order to pass legislation, even during the time period in which they routinely did have bipartisan support for doing so. It's not clear that anyone thought it was blameworthy if you could not get bipartisan support for a particular piece of legislation. But there were institutional features that certainly encouraged the fact that we had bipartisan support for legislation. You had to overcome a Senate filibuster. You had to overcome possibility of a presidential veto. There was less political polarization, such there was a lot of overlap in policy preferences among the two parties, such that you often would get bipartisanship just based on where people's policy preferences tended to lie. So it becomes an interesting question then if you are now trying to move a piece of legislation through Congress and you can't get bipartisan support for it, have you somehow violated a norm by continuing to push that legislation forward despite the fact that you don't get support from the other party? Likewise, we've had this conversation recently in terms of presidential impeachment. For example, is it appropriate to move a presidential impeachment forward if you do not have bipartisan support for it? In what sense is that just misguided because it's not likely to be very successful under those circumstances? And to what degree is that actually blameworthy behavior, such that we think we're undermining something important about the constitutional system itself? I think some of those questions are going to turn on how important we think that particular practice is to helping sustain the larger workings of the democratic and political system more generally. Some kinds of practices we can abandon without having lots of consequences, lots of negative consequences for how the constitutional system works, certainly not lots of negative consequences for the limits on government power more generally. But some I think we should be much more worried about if we wind up losing them and having them break down in various ways. There's a reason, for example, why we expect the DOJ, for the most part, to be relatively independent for presidential intervention. There's a reason why we think it's inappropriate for Congress to interfere with the size of the Supreme Court and to pack the court by adding additional seats. It's not just the fact that these are longstanding practices, some more longstanding than others, but it's also a fact about if we change those practices, what are likely to be the consequences for the political system as a whole. And at least some norms, if we start violating them, we should worry that there's going to be bad consequences, not only for people's support of the political system, but also for how well the constitutional system is likely to function and what kinds of limits on governmental power are likely to exist.
Thank you, Professor Whittington. And for those of you who are watching on YouTube or Facebook, I think you're able to ask questions through the live stream. If you're interested in doing so, please do so now, although I will ask a couple of questions myself. But before I do that, I wanted to go back to the panel to see if anyone wants to respond to something that one of the other panelists said. And maybe, Dina Mara, we go back to you if you have something you want to add and work through the roster one more time.
Sure, thank you, Judge. I guess I would just follow on what Keith just discussed, which I thought was very elegant and helpful. I do think that when we differentiate between a practice or just a historical pattern on the one hand versus something that we're prepared to call a norm or a subconstitutional way of operating on the other hand, does have to do with why the practice developed and the sense of self-restraint or interaction, mutual interdependence that we might want to facilitate with other actors in the system. So I do think, for example, the picking people from Yale Law School, let's use Yale rather than Harvard, Keith, for the Supreme Court, that's not kind of something a president does or presidents have done so much as a self-conscious restraint. It might be a default, making it easy kind of a thing, but it's not about institutional relationships and divisions of power in the same way that faithfulness in electors really is. I mean, the idea that these electors have any basis for exercising independent judgment is quite laughable. It's laughable today. I think it was laughable 150 years ago. And then second and related, I think whenever someone does deviate from something we're prepared to call a norm, there too, we want to look at the why. So just as we wanted to look at why the practice ripened into a norm, we want to look at why someone thinks it's permissible or legitimate or beneficial to deviate from it. So again, I think, Gerald Ford's pardon, even though it was kind of unprecedented in certain ways, is very different than other presidential potentially self-serving pardons or other actions. A lot goes back to motive. Again, if President Trump had discontinued an investigation of Hillary Clinton, that's very different than him firing James Comey. Or if he wants to condition foreign aid on corruption investigations, it's very different if it has nothing to do with his chief election rival versus the son of his likely opponent. So motives matter both in the elevation of a practice to a norm and also justifications for deviation therefrom.
Great. Professor Kammaker, anything you want to add?
Sure. Let me first say I thought that all these remarks by my fellow panelists have been very interesting, thought-provoking. Just a couple, starting with something that Professor Whittington talked about, this whole question of when do we decide that deviation from a norm is problematic or blameworthy and when not. Another variable that might be worth thinking about has to do with the role of a norm in creating stability and itself being a precedent for other actions around it. So there are some norms that when broken, we might all say, huh, didn't see that coming, or, you know, we can debate the pros and cons of it, but nothing really changes in the world. So I would put into that category President Trump's decision to use Twitter as a formal mode, a foremost mode of communication with the American people, right? Some of us found it kind of jarring, those of us like me who don't have Twitter accounts and don't know what's going on. Other people thought it was fantastic, and he was able to reach a whole new audience in various ways, etc. But one way or the other, we all adjust and move on. On the other hand, just to put into the other category would be your example of the faithless electors, because we have a system of selecting a president that has come over time to rest on the assumption that electors are going to be faithful and that they will, you know, with maybe one or two exceptions every year or something like that, they will by and large do what they are supposed to do. And if it turns out all of a sudden that that norm breaks down and that electors feel themselves empowered to vote for whoever they want to for president, then a lot of other things will have to change in order to reorient the system to get back to something that looks even remotely like what we have now, which is something like a popular election filtered through the college for a president. I have one other comment that I'll offer now in response to something that Professor Bernstein said, which is kind of a scary reflection, right? He set up the question of whether or not a Republican president following President Obama would recognize the many excesses that President Obama engaged in. And I think Professor Bernstein did a terrific job both here in his book and in identifying a large number of those. And then just saying, well, but now that I'm in power, I'm gonna shut it down and I'll rein back in my own powers. None of us are really surprised that that didn't happen. And it's not just because of who Donald Trump is, it's because any right-thinking president who came along would say, well, this is the new normal, let me do what I want to do. And it seems to me the only way that that's likely to end is if a president, a new future president, has no need to push the boundaries of his powers. And that would only be because he's got a Congress, both houses of Congress, with which he's in sync. And they're all thinking alike. So pretty much anytime the president wants something done, he can in fact go by and large work with Congress and get something that looks like what he wants accomplished the old school way through legislation. So that might bring to an end the notion that a president will feel like, oh, I've got to push my boundaries, but it will only be because you've got both operators now moving in the same direction, which of course is going to magnify one of the other concerns that we have right now, which is partisanship, which means we're going to end up with a government that is moving much more towards either the left or the right. And then we're just going to be back here debating other arguments and other concerns. Was that a result of gerrymandering in the background? Was that a result of some problem with having the Electoral College and not the popular vote? Was that because of specific ways of operation, let's say the filibuster that do or don't allow, or the end of the filibuster perhaps coming our way, that allow bare majorities in the Senate maybe to be more powerful than they used to be? So I'm kind of worried that we're in trouble either way, right? Either we're going to continue to see presidents chafing at the restraints imposed on them by a constrained Congress, or we're going to see presidents who don't feel those constraints, but it's only because the system's going to be careening wildly one direction or the other.
Professor Bernstein, anything you'd like to add?
Just very briefly, I want to leave some time for questions. I mean, there is one irony of the Trump administration, which is that while Trump has certainly not expressed a desire for restrained executive power or manifested such a desire, he is appointing judges and justices who seem inclined to potentially restrict some of the broad delegations that Congress has been giving presidents since at least the 1930s, that give them at least a patina of legal basis for a lot of the things that presidents probably shouldn't be doing unilaterally. So it may turn out that restricting delegation, Chevron, and other doctrines that tend to give the executive more power may be Trump's legacy, and it may not do much for norms as such, but it may give less legal authority to the president when he feels he needs it to do things outside of the compromises with Congress in the normal way bills and legislation should get passed.
Pastor Whittington?
Yeah, let me just briefly put one more issue on the table, I guess, for us to think about, and maybe some questions raised as well, which is how we go about enforcing norms, right? So one, we're used to constitutional rules that we enforce, for example, through judicial review, as well as other mechanisms. Norms are much trickier about how we enforce them and maintain them over time. So think about the classic example of a norm, which was the tradition of a two-term presidency, in which the idea was the president shouldn't run for more terms of office than George Washington himself had established. We thought this was an important constraint on the presidency and a way of preventing presidents from becoming dictatorial leaders. One thing that helped preserve that over time, besides just the fact that presidents often were not very popular by the end of their second term, was the fact we had lots of gatekeepers in political parties that could force presidents to limit themselves to 2 terms. So when some people thought, for example, it would be a great idea for U.S. Grant to run for a 3rd term, there were party leaders inside the Republican Party who pushed back and said that it was inappropriate. You shouldn't have a president run for a 3rd term of office. Once those kinds of gatekeepers, though, break down, it's very hard to know, okay, how do you continue to enforce the norm more generally? Do you simply rely on the self-restraint of the political leader? Are you relying upon the mass public, for example? These things are often going to be very difficult. In the case of 2-term presidencies, of course, we built it into a constitutional rule instead, but we can think about similar things in terms of the norm for presidential candidates to release health records and tax returns, for example. That are we really just relying at this point on the mass public to enforce that norm by refusing to vote for somebody who won't do it, which often seems like a not very effective mechanism if we think that norm is particularly important.
Well, great. Well, let me throw in a question or two. These will be a jump ball. Whoever wants to chime in, please do. But a lot of the discussion has been about norms of what I would say the executive branch. And the theme, I think, pretty consistently has been that the norms have changed there to aggrandize the power of the executive. You can point to specific executives, but the point seems to be that it's all moving in the one direction. If you think of the separation of powers or balance of powers as sort of a zero-sum game, that means there must be a necessary decrease in power or one or the other of the other 2 branches, or maybe both. Are there reforms, or are there things that you think Congress, for example, should be doing to help change the norms, or perhaps pull power back to the legislative branch, or those of us in the 3rd branch, the least dangerous? Are there things that the judiciary should be doing to help level the playing field a bit when it comes to changing norms? Okay, Dean Amar?
Well, I'll just mention 2. I mean, David mentioned one, and that is the seemingly increased willingness of members of the judiciary, and especially the Supreme Court, to revisit the moribund non-delegation doctrine. The idea that, if Congress is giving away emergency powers to the president without defining even what an emergency is, then the court will force power back to Congress by invalidating some of these broad delegations. So there's an instance where the court might be playing a referee between the powers of the other 2 branches. And then with regard to the court itself, another one that was mentioned was the court packing plan. And that's an attempt by Congress, maybe having to override a presidential veto, likely. But again, in these hyper-partisan days, unlikely to succeed. But let's say you got President Biden and a Democratic House and Senate. Would they ram that through in a way that constrains maybe future Republican administrations after they get the packing done that they would like to get done? And I want to go back just briefly to something Evan said. He said, well, it was no surprise that President Trump kind of used all the precedents that President Obama had created to his own political aims, and that's just the way it works. You're always going to tat for every tit for every tat that came before. I hope that's not right. For example, I'm not happy with the way judicial nominations have been handled by the Republican Senate in recent years. But I'm an opponent of the court packing plan. I think that I don't want escalation. So maybe at a minimum, Evan, what you're suggesting was, each party will use the precedent that the other party developed. But I hope it doesn't go beyond that precedent. And what I worry about is escalation and this stair-step game. Maybe you can't unilaterally disarm, and maybe you got to do what was done to you. But I don't know about kind of retribution that goes beyond the four corners of what's already been established.
Yeah, if I can jump in, I didn't mean to suggest that it will be an ever increasing escalation. I didn't mean that. I meant I agreed with David's point that it was silly to think about it, the Republican president coming in and actually scaling everything way back under circumstances where, given the way, on the assumption it was any Republican president and a Congress that, however was balanced, was not going to be overwhelmingly supportive of the Republican agenda. The Republican president would end up doing a lot of thumb twiddling as time went on. And my sense is when you get to that point, you start chafing again. I just think that that's kind of human nature.
Anyone else? Okay, great. I'm in the position of being in every law student's dream in that I'm getting to call on law professors myself rather than the opposite, including a dean and former dean. So this is wonderful. And I'm going to exercise that prerogative one more time. In listening to your really terrific presentations, there were some reminders of some matters I was involved in before I became a judge. I was a litigator and was involved in some of the cases you all talked about, whether it was the travel ban or the census, the Affordable Care Act, faithless electors. And in virtually every one of the high-profile cases that I was working on, states were actively involved. And I sort of wanted to ask you about the role that states play in helping drive maybe even our federal norms. One way is through litigation. Every major piece of litigation these days is either brought by states, sometimes against states. Sometimes states are intervening, or at the very minimum, we have states filing really important amicus briefs, sometimes one group on one side, one on the other. We also have states maybe pushing different prerogatives, say in the immigration space or other areas that might push on federal prerogatives. And so we have battles there that are both legislative and political. Does anyone have thoughts about whether how states sort of play into our changing norms, and if it's having a positive, negative impact, or anything else? Dean Amar.
Yeah, I think it's a great question, Judge. And I do think that whether it's by engaging in litigation with the against the federal government, or by defying the federal government in other ways, you do see a much more robust federalism at play today, where cities and states are registering their disagreement with federal policies and doing everything they can to slow those policies down. And immigration, which you mentioned, I think is a prime example. The debate over sanctuary jurisdictions and when states and local governments have to cooperate with ICE and when they don't. I think it's a great kind of a test case. The one thing that I think troubles me about what otherwise I find a very healthy tension between federal government and states to keep each other in check. I think that's one of the most important features of our design, is that people at state and local governments today, they don't seem to recognize that when they want to do things, they should be held to the same standards of federal supremacy that apply when the political identities and agendas are inverted. So let me give you an example. The city of Berkeley passes a law that says an ordinance that says if you do business with the federal government in building a wall, you can't do business with the city of Berkeley. Or the town of McFarland, made famous in the Kevin Costner movie McFarland, USA. Just 2 weeks ago, I saw a New York Times report. I wrote a Justia column about it. I don't remember whether it's posted or not yet, but there was a privately operated California prison that was being shut down because California was getting out of the business of using private companies to run their prisons. And so ICE wanted to refurbish these facilities to use as a detention center. And this company, GEO, they needed some local zoning variances to be able to contract with ICE for this purpose. And under intense political pressure, the city council voted, or the zoning commission voted against these variances, even though it was an economic lifeline for this otherwise very struggling Central Valley town. And I say, well, okay, wait a minute. If this was 1960 and a local town in Alabama wanted to deny variances to some entity that was partnering with the federal government to promote voter education or to teach people how to take the citizenship test and pass it, would we say that cities and localities and states had that power? So just as with the First Amendment, federalism has to be a neutral principle. And I'm worried that we're losing any sense of neutrality in any of these structural themes of the Constitution.
Yeah, Professor Whittington.
So it's an interesting question what states can do, I think, in this kind of context of primarily federal norms. Of course, states in their own internal operations have their own sets of norms, and they're struggling over those as well. One feature of norms is we might think that they are largely not institutionalized, although you can imagine some ways states might try to help institutionalize a set of norms through litigation, through statutes, and the like. We can also think about sort of informal things states can do to try to put pressure on federal officials they think are violating norms in various ways. You might think of the sanctuary cities movement as being an aspect of that, of saying states saying we're going to use our own powers to refuse to cooperate with federal government officials who are conducting their policy in a way that we think violates traditional expectations about how exactly immigration policy is going to be implemented, for example. I think about sort of the case of President Andrew Johnson, to go back to sort of a set of presidential norms, for example, where he went on a tour of cities in 1866 leading up to the midterm elections and used what were traditionally understood to be ceremonial political events to make them into partisan political events. And one consequence was local government officials stopped showing up for those events. And so presidents traditionally could be expected to be on stage with all the local bigwigs. Andrew Johnson increasingly was isolated. The local bigwigs wouldn't come be on stage with him if he was going to use his presidential platform as a partisan device rather than primarily a ceremonial celebratory device. And we can imagine similar ways in which in a modern context, state and local officials can push back against federal officials they think are misbehaving by speaking out against them and reinforcing a set of norms about what our expectations are about how political figures behave, and by ostracizing political officials they think are behaving in bad ways.
Yeah, Professor Kamaker.
So a couple things. There are lots of ways in which states have, for long periods of time, tried to influence federal policy and do so in part by influencing federal actors. And one of the gatekeepers for that is, of course, your job as an Article III judge, right? There are lots of times when courts have to come in and step in to decide when is a state court overstepping its boundaries. One example is the recent one in California, which passed legislation essentially requiring aspiring presidential candidates to reveal certain kinds of taxes and financial information, which has now been struck down. The other is the case I talked about that's before the Supreme Court, where the district attorney in New York is seeking President Trump's tax records. And his argument basically is a federalism argument, that the state cannot do that because in some sense it's exerting too much influence control over the federal government. As I already shared, I think that on the particular facts of this case, dealing with just investigation, I think that's a weak argument, but it's a much stronger argument if the state actually went further and said, now we're going to actually prosecute the president and assert a claim that we could actually put him in a state jail if in fact we find that he did something wrong. But I also want to go back to the very beginning of the conversation with when both David and Vic were talking about the issues of presidential motive, because today we are also seeing an increasing resort by presidents to pressuring back against states and localities that are in a sense trying to hold them in check. So a couple of examples of that would be when President Trump, I'm not sure how much this was actually carried through, but made some noises about, well, if we need to release certain people coming across the border anywhere, we're going to dump them into their sanctuary city. There was a recent Twitter, I guess I'll call it a conversation, if that's what we say, Twitter conversation where President Trump was speaking to the governor of New York, Cuomo, and basically said, if you really want me to help New York out in various ways, one of the things you have to do is stop these harassing lawsuits, by which I think he meant the very lawsuit I was talking about earlier. So with the growth of presidential power, we are seeing new ways that presidents are trying to actually control states that are exercising their initial prerogative to try and control the federal government. It was very interesting times.
Professor Bernstein, I don't want to leave you out here. Did you?
Sure. Just on federalism more generally, as power has increasingly flowed towards the federal government over the last century or so, that has made elections more of a federal elections more of a winner-take-all process where one side gets to make policy for the whole country. That was mitigated for much of that period by the fact that you had to get things through Congress. Congress has supermajority rules. You needed cooperation from at least some people in both parties. So now that the executive branch is making so much policy on immigration, environment, civil rights, and so on and so forth unilaterally through executive orders and regulatory changes, the elections have really become winner take all. So that President Trump or President Obama can make really significant changes in federal policy on issues that people really care about without any buy-in from the other side at all. So elections have become increasingly winner take all, and I tend to think this is a major reason why bitter partisanship has overtaken the country, and I think devolving more authority to the states so that the importance of federal elections is decreased would go a decent way towards limiting the partisan bitterness.
Great. Let me turn to some questions that were submitted. I have one from Gene Meyer, the president of the Federalist Society. He asks, in general, is there anything any of you would suggest that could minimize the damage done to those who try to support norms and challenge their own, quote, side in the process? Is there anyone interested in taking that on? All right, the Dean.
Well, it's a big and a hard question. But I do think if elected leaders and certainly individual voters can think about the longer term and not just about the shorter term, they're going to be more cognizant of the damage being done to the system and how every action is going to generate not maybe an equal and opposite reaction, but an even more powerful reaction. And so any device you can have for putting yourself down the road and imagining how this will play out. So that's why I'm so opposed to court packing and the like. Let me give you an example. So, we've talked a little bit about the Electoral College and electors and the like, and a national popular vote, Evan mentioned. I've been one of the most kind of vocal, frequent analysts discussing the so-called national popular vote interstate compact, which is an idea that my brother and I and Robert Bennett from Northwestern advanced a couple decades ago, whereby states would give their electors not to the candidate who won the particular state, but to the candidate who won the most votes nationwide. And there are lots of wrinkles in how that would operate. But a lot of people who think this is a partisan ploy to help Democrats who have lost the Electoral College twice in the last 20 years, but won the popular vote. It's a ploy to get them elected. And I don't think that's actually true. And I think empirically, A lot of people thought that Gore would win the Electoral College and lose the popular vote, and Kerry almost did so in 2004. And candidates play based on the rules of the game at the time, so you never even know who will win the popular vote if we changed the rules so that the popular vote winner did become president. But in any event, if you're worried about this kind of partisan gamesmanship, what I've written is, okay, let's all agree on the principle that it would be good if the president had popular national support, and that would eliminate the undue emphasis that swing states have, large swing states. It would be more of a national election. It wouldn't narrow down to 6 or 8 key states. If you believe in one person, one vote, and a national election, then let's adopt this thing and implement it in 2032, not 2020 or not 2024. And in 2032, we have no idea what the partisan implications would be. And so devices that we can have to take ourselves out of our partisan mindset today, and look to a time when maybe we're not so striven and decide what the right thing to do is for democracy. I think those are the kinds of exercises, intellectual exercises that we should be engaged in.
I have to say those of us in Ohio have enjoyed all the attention we get because of the Electoral College. So
exactly, QED.
But fair point. Anyone else want to weigh in?
Sure. I since Gene asked the question, I hate to seem like I'm sucking up to him, but I actually think that the Federalist Society is a good model. We could use more organizations like the Federalist Society. While the popular imagination and in the op-ed world and Twitter, the Federalist Society is the partisan villains of the Trump administration. In fact, there's no orthodoxy, and there's certainly no partisan orthodoxy in the Federalist Society. And here I am. I've said critical things about Trump in this talk. I'm not going to be disinvited from future Federalist Society things. My colleague Ilya Soman is much harsher, is really, really hostile to Trump, let's say, along with some of my other friends who are in the Federalist Society. They come to the meetings, they're speakers, they're treated with kindness and respect by everybody. There's no sense that to be a member of the Federalist Society, be active in the Federalist Society, or even be a leader of the Federalist Society, you're required to support any given policy or even the presidency of any given Republican. And I think organizations like this that have that sort of intellectual integrity are becoming fewer and further between. And I just wanted to point that out and hold it up as a model.
All fair points. Anyone else? Or okay, we will turn to a student question from a student. Oh, now the question has gone off my screen. There we go. To a student from BYU who goes back to the topic of social media, something that a couple of you have mentioned earlier. The specific question is, with today's pervasive social media, are changing political norms actually due to sort of popular majority support, or simply due to the few leveraging echo chamber effect of social media? And maybe more broadly, the question is, what impact is social media having not only on sort of everyday norms, political norms? Are those good developments, and maybe how do you see those things playing out going forward? All right, Professor Kamaker.
Well, as I said, I may be the last person who should speak on this because I don't have a Twitter account. But I would say this is not a direct answer, but it amplifies the question. I think that a lot of people expected that the growth of social media was going to encourage younger people to become much more politically engaged and politically involved. And I think there's many different measures that show that that's true, that there are more young people today than there had been ever before, paying attention to current events, taking in information, et cetera, et cetera. But I think it remains to be seen whether or not that's necessarily a positive thing. And I say that partly because of the extent and threat of disinformation from all different sources on social media, and the way in which young people, like everybody, can tend to get into some kind of an echo chamber. But I also think it's interesting, obviously this is really early in the Democratic primary system right now, and we don't have a Republican counterpart to it yet, but there doesn't yet seem to be any evidence that young people are turning out in larger numbers than they had in the past to vote for president, which would be at least one plausible measure of engagement in the political system that might have been pushed by greater access to political commentary, political stories, etc. So it may well be just that we're too early in the process of social media. We don't quite know where it's all going to go. But as of yet, it doesn't, to me, it doesn't yet seem to be revolutionary in any particular way. It seems to be just yet one more quicker source of information, which is quick in the good way of getting important information out, and quick in the bad way of bad and sometimes false stories having a life of their own.
Sure. Professor Whittington?
Yeah, just to build on this a little bit, I think that one sort of underlying feature of that question is who's the relevant community that helps support norms or also undermines them. So if we're changing norms, is a function of because the people in general want it, or is it something else? And there's certainly a set of norms that are a function of mass public opinion, we might imagine, but an awful lot of political norms that matter for how political actors behave are really elite-driven norms. They're not really necessarily something the mass public has much stake in, knows very much about, or even would be very supportive of if you were to highlight it to them. And so some of Trump's unusual rhetorical behavior, for example, we might think of as breaking traditional norms about how exactly presidents are supposed to criticize judges, for example, or criticize other political leaders. Those may have been expectations among a set of political elites, but not necessarily something the general public cares very much about or would necessarily be supportive of if you push them on it. So I don't think we should necessarily think about the desirable feature of norms is that they all rest on mass majority support. Sometimes we might think norms are a very good idea, even if a majority of the people, in fact, would prefer we tend to operate rather differently.
Dina Mar.
Yeah, I just want to double back to something Keith talked about earlier, and that is, you know, putting aside whether a particular norm is a good thing or a bad thing to maintain, enforcement of norms has often involved what he called gatekeepers, members of this elite, whether party leaders, intermediaries, et cetera. Social media has allowed presidents and other folks to circumvent all of those gatekeeping intermediate elite institutions and individuals. So whether it's a good or a bad thing, I think it's easier to depart from norms when you can make your appeal directly to the people and you don't have to rely on all these elite apparatuses in between.
Great. We probably have time for one last question. Unfortunately, I can't get to all the questions, but we had a question from a student at Michigan Law School, so I thought that would be an appropriate way to end. The question says, thank you to all of you for doing this and for taking questions and for your flexibility. The question is about our current health scare. What are the panel's thoughts on COVID-19 and the federalism norms you've been discussing? Maybe more broadly, obviously our current situation is impacting daily life in many ways, and that may well impact our political life and political norms. Are there thoughts about, in the short term or long term, how this will impact our political norms? And Dean, you have your hand up, so up to you.
Sure, it's kind of funny because I'm actually in Ann Arbor as well, a few blocks away from Evan, but he and I were talking earlier today about just this thing and how interesting it is that we're having this event today and we're not really directly focused on what's all on all our minds from all that we're seeing on TV. But one comment that Evan and I discussed was how the response over the last 3 or 4 days, and it really is 3 or 4 days. I mean, 5 days ago, I was talking about Illinois beating Michigan for a third time in NCAA hoops in the second in the Friday round of the Big Ten tournament. But it's interesting how the response in the last 3 days has come from the grassroots up to the federal level. So who are the first movers in this transformation in the last few days? Well, it was private universities like Princeton and Harvard, and then public universities, Illinois and Michigan. And then it was governors and local school boards, K through 12. All of the mandatory changes in our lives today really are not coming from the federal government. The declaration of emergency yesterday frees up federal money and relaxes regulations, but it's not really regulatory. It's deregulatory, and it's kind of interesting that at a time when people might think we need kind of some overarching mandatory rule that all of us have to obey, that it's really trickling up from below. And maybe that's a good feature of federalism. And it's not even just federalism, it's the private sector. It's the NC2A, it's the NBA, it's the NHL, it's Disney. They've been leading the way. They've been pushing the federal government to get where we are today, which I think is a very interesting phenomenon that we'll be commenting on down the road.
Great. I'll work through the rest of the order so everyone else can have a minute or so to wrap up. Professor Kamaker.
Well, not surprisingly, I agree with pretty much everything that Vic said. But I would also add, it really adds to this point about the evolution of more delegatory power to the federal government. And at some level, as we've discussed for probably several decades now, when you talk about federalism, it still is very difficult to distinguish between the general system and what your priors are. So this may be a case where a lot of people on the panel may have been thinking to ourselves, all right, maybe this would be a good time to retrench federal power. Or maybe if we had less federal power, the states had more federal power, some of the other problems we've discussed might go away. And then something new comes along, like a virus like this that seems to have higher, and I'm not sure if this is true or not, we're still waiting to know, but seems to have higher levels of transmission, at least in a time period when there is so much more global movement and cross-country movement than there ever has been before for other kinds of pandemics. And just go back to what Vic said, if the state and local governments and private institutions, for whatever reason, had not been doing what they're doing, would we have wanted the federal government, whether it's Congress or the president, to be able to say, I'm putting a restriction on interstate travel. We're shutting down K through 12 state-run school systems. It's an interesting question about whether new emergencies will re-engage this debate about what is the appropriate level of emergency federal power.
Thank you. Professor Bernstein?
You know, one thing that this crisis has brought home to me is this issue of the norm of the president having his ceremonial role and being, you know, the leader of the whole country versus the partisan political actor that he is, and that's been diminishing for some time. But certainly, especially in the era of Trump, we have a situation, and you know, this goes. I think there's fault here on both sides. But we have on the one hand Trump acting in a very non-ceremonial, partisan way at inappropriate times. In other cases, people, you know, sports teams are unwilling to meet with the president to be congratulated because it's Trump, when really the president's serving, you know, in theory at least, as the head of the country, not as the political person. And it has led me to think that countries that have a separate ceremonial leader may have an advantage, and it's maybe a flaw in our constitutional system that we don't have the equivalent of the monarchy in England. Though I don't like monarchy, but maybe a better example is the president as opposed to the prime minister of Israel, who is the ceremonial person who does the handshakes and the congratulations and meets the celebrities and all that kind of stuff, and would be the person he would be looking to for sort of reassurance and guidance and, you know, non-political acts with regard to this virus. And instead, we have a situation where, you know, a lot of people don't trust the president. The president is, you know, in fairness, seeming to be very partisan in how he's reacting to things. And maybe if we had somebody else who wasn't running for re-election, who could represent the federal government in this way, that would be a better thing.
Well, it'd certainly be a fair change in the norms to have a king and queen. So
Yeah.
change that for save that for another panel. Professor Winnington, can you take us home?
Yeah, so I think there are certainly interesting features about our present moment and in this regard, and some of them were just the ones highlighted. It is a little striking that one thing President Trump has struggled with all across his presidency is serving that kind of unifying ceremonial force that we have traditionally wanted presidents to serve. Partially, he doesn't seem to occupy that role very well, but also other people won't let him occupy that role very well because all of his actions get framed in primarily partisan terms. I think that's partially just a feature of the nature of our current political system. All presidents, I think, are going to struggle with that to some degree. That has some immediate consequences in our present moment. But likewise, there's been this interesting pressure on the extent to which the president has also served as a national leader in moments of crisis. through much of 20th century American history anyway. President Trump has not been very effective at doing that. And lots of other people have stepped up and served that role. I think that's the strength of the system, that there are other people, both private actors as well as other government officials, capable of occupying that kind of leadership role and helping to draw the country forward. Others, I think, are more critical of it. Obviously, I think there's a federal role here, a presidential role, that may not have been played out very well. But I don't think there's anything wrong with the idea that others also can be leaders in these moments of crisis. It also emphasizes how fluid these situations can be, including these longstanding practices. There's nothing natural or inherent about presidents occupying this kind of leadership role. It's possible for presidents to sink into the background and for other figures to come to the fore in these kinds of moments. And we may be seeing that now. Whether that's particularly durable, continues beyond this presidency, continues beyond this particular moment is a different question. But I think there is some fluidity that tends to be built into these kinds of things, that sometimes we take things as being very fixed and permanent, and they're not always so.
Great. Well, thanks to everyone. It's a real credit that the Federalist Society is willing to put on programs where you hear from diverse viewpoints, and that was certainly true today. Really 4 terrific speakers who each brought a slightly different perspective to the discussion. So please, in the back of your minds here, a thunderous applause coming out from our nationwide audience. Again, thank you very much to the Federalist Society and to the student chapter at the University of Michigan Law School for all of your efforts to put together a great program today. And I hope that we can all be together in person before long. So thank you, everyone. Have a great afternoon.